Micah Smith,
Yes, I'm here.
you're supposed to be in Judge Buchanan's courtroom.
Buchanan.
Judge
I
Buchanan.
was just told to join this one as a witness
Excuse me?
to a case. I was told to join this one to a witness
Yes.
as a witness to a case.
She's on the docket today?
No, she's here for the Terry Smith. You said she could have.
I'm talking to my court officer, my court reporter. Do you have a case before Judge Buchanan today?
Yes, I did. I haven't seen him yet though.
You need to take care of that first before you get a bench warrant.
Yeah, they haven't called me back yet, so that's why I was
Who
trying.
hasn't called you back?
And I thought today, Miss Judge Buchanan, she hasn't called me back there yet. But
Oh, are you
I
in
thought
the building?
I'm waiting right now. But I thought that this court was at 10 o'clock. So that's what that's where the mix-up came from.
I'm not understanding what you're saying. You're in Judge Buchanan's courtroom right now?
No, I'm outside of the courtroom waiting to get called back.
Yeah, that's what I was asking. Are you in the building?
Yeah, I thought that
Oh.
this was at 10 and this was at 8, so that's where like the mix-up was.
Okay, the prosecutor is aware that you're here, so you're fine. You're in the building. So you take care of Judge Buchanan for that purpose. Which matter was she on for yours?
Terry Smith.
Okay, he's noted that you're here, so you're all set for our purpose today, okay?
Okay, thank you.
You're welcome. This is the state of Michigan versus Martha Thomas, 25-00340. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, there on behalf of people.
Assistant Public Defender Joseph Hardy, on behalf of Ms. Thomas, who is making her way to the defense table. That's okay. Paperwork, permission to approach room.
Okay, this matter was scheduled for jury trial today. My understanding is that Ms. Thomas is going to plead to the charge and pay restitution.
Yes, Your Honor. I've spoken with defense counsel. After reviewing the file and the amount of the damaged product here, the people have amended the count to malicious destruction of property between 200 and 1,000, and the defendant has agreed to enter a plea to that charge and to pay restitution in the amount of $629 to Mr. Carlin.
You're upgrading the charge?
Yes, Your Honor.
How's that a plea offer?
I don't think it's a plea offer. I think it's we should have charged that from that.
I recognize that. We're not doing that. This was offered for her to plead guilty to the charge and pay restitution. That's been the offer on the table. Not upgrading the charge today. The motion to upgrade is denied. She can plead to the charge, which is what it says, as charged, on the plea sheet, and she can pay restitution. But a motion to upgrade the charge today is denied.
Okay.
How does she want to proceed?
As that was our original understanding, we would like to proceed. I'll discuss I'll discuss her pleading to the charge of malicious destruction of property less than $200.
Where's the restitution sheet? Is she agreeing to the amount of restitution?
Yes, Your Honor.
Who is this person in the back? Who is that?
Myself.
He's shaking his head. No, she's not. Are you, ma'am, are you agreeing to the amount of restitution?
Yes.
Okay. How much are you agreeing to?
It's saying $200.
Okay, so it's $200 for restitution?
The item costs $629.99.
You're agreeing to pay $629 for the item?
I agree.
What is the item?
It's a firearm.
And it was damaged?
Yes, it was Chisel didn't have by the defendant.
I was protecting my daughter's life. I was figuring my daughter's life. It was a domestic dispute between.
Oh, well then why are we not having trial?
Because he said I need
No.
to plead guilty because the jury would find me guilty.
So that, understand that I went over with this and asked her if she believed that she was guilty as we get to the factual basis. No, she had stated, yes, that she did believe that she was guilty. That was what we were proceeding under. I believe that what her explanation was an explanation for why she committed this act, but I don't believe that there was any.
What are the elements of malicious destruction of property?
Willful and malicious destruction.
And you understand the definition of malicious? Okay, and her position, I don't know I don't know the personal facts. That's what you all know. But she's claiming, at least on this record, that there was a domestic dispute and she was protecting her child's life.
I have the texts in there. I have been texting him to please just leave it alone, just stop it. He wouldn't, and he kept calling. I would have gave it back, but he didn't want it back until they was in that domestic dispute when he was mad and upset with her going
Let
over
me
there
stop you.
trying to break.
Raise your
in.
right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
Okay, you understand that you have the right to remain silent. Anything you say can be used against you.
I do.
You understand that you have the right to proceed to trial and be presumed innocent until proven guilty. This matter goes to trial. You can maintain your silence. The prosecutor has to prove each element beyond a reasonable doubt. If you plead guilty, you would have to give up your right to present any testimony or evidence of defenses that you believe you have to the charge. You give up your right to question or cross-examine any witness that they're going to call, and you give up your right to take the stand and give testimony. You understand that? Okay, and so your position is that there was a domestic dispute that you were protecting your child from. Are you saying that there was an active situation happening when you destroyed this, or allegedly destroyed this firearm?
Yes, I have texts
There-
where he was
not-
trying to break in her house and he stole the camera, so.
I'm talking about at the
Oh.
time that you allegedly destroyed the item. Was it when there was an active domestic concern?
Yeah.
That you're saying that this person was actively seeking to assault your child in that moment?
Yeah, yes, during that time.
Not during that time, right now. He's getting the gun to shoot her right now. Do you want to get kicked out of my courtroom for talking out on my record? Then control yourself. You see this right here? You have control over it.
Can you repeat that, please?
There was an active threat at the time that you allegedly destroyed this?
But it was, yes.
Okay, you need to talk to your attorney. I can't accept the plea. You can figure out, I don't know what the threat was or if there really was one. If there wasn't, you need to explain to her why it wasn't an active threat. If there was, we'll call the case back after you speak to him. State of Michigan versus Lionel Barkley, 26-00703, counsel appearance.
Thank you, Your Honor. May it please support Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Who's representing Mr. Blair? Same attorney? Okay, of your appearance, counsel.
Assistant Public Defender Justice Drive on behalf of Mr. Lionel Barkley, standing in for Mr. Joseph Harding.
This was a final pretrial for disorderly person and assault and battery. Do we have the complaining witness here?
We do not, Your Honor, the people move to dismiss this case after talking with the complaining witness and understanding the facts and circumstances surrounding it. So we move to dismiss.
Objection.
Motion to dismiss is granted. We'll get your dismissal in just a moment. Take your hand out of your pocket, please, sir. Thank you. You have any questions?
No.
Okay, we'll get your dismissal in just a moment. State of Michigan versus Austin Heffley, 26-00385, appearance, please.
Thank you, Your Honor. May it please the court, Senior Prosecuting Attorney Dan Smith, here on behalf of the people.
All right, take that.
Assistant Public Defender Justice Straub on behalf of Mr. Austin Heffley, standing in for Mr. Joseph Harden.
I reset this matter and converted this to another final pretrial because this was scheduled for a PA 53 previously, and the prosecution's office represented to the court that there was a detective that was assigned and that the detective failed to provide or follow up. I requested the prosecution offer provide me with the name of the detective and the date that the matter was referred. So that the court can follow up on why that detective failed to follow up. Can I have that information, please?
Yes, Your Honor, and thank you again for giving us an opportunity to figure this thing out. So after reviewing the case file in this matter, it's my understanding that the defendant had a similar case out of the 55th District Court. That matter was charged, I believe, in early January of this year. The defendant then was alleged to have committed a new domestic violence against the same victim, which happened to be a bond violation on the 55th case. And then he also was alleged to have committed an additional bond violation in this particular case. So it was a matter of just figuring out which bond violation was which court. And
I have the jail calls now.
so Detective Booth was assigned to our particular file, and she did make a finding where there was jail calls related to this particular case, although there were jail calls related to the other case as well. No one was assigned to that particular one, but Booth was assigned to this one. So she was assigned, she drafted a complaint for the additional bond violation. So we would be prepared to move forward with that violation today, but I believe the defendant has agreed to plead guilty to the underlying charge.
Our court received a copy of the violation on this, or the report on the 17th. They listed it as if it was a new violation when they received it on the 17th of April. But I have now a incident narrative supplemental report 26-01083-3 by Detective Booth, which indicated that on March 4th, she was assigned the file. She spoke to APA Buckingham, who advised of knowledge of a no contact order violation against the defendant on 2/19. It also should be noted on this record, the defendant was arraigned by Magistrate Milmore on February 13th, and he was advised that he's not to have contact directly or indirectly with Josephine Rose Park. We have where the investigator listens to jail calls, which are recorded, and there was a conversation between Heffley and Park. I miss you. I'm sorry I was angry. Angry asshole. Heffley stated, they finally lowered my bond to $325. Park to Heffley, when you hit me in the stomach, I bled. I thought I miscarried. Heffley, did you? Park, no. Heffley, I didn't mean to hit you, baby. I'm sorry. If I get out of here, would you let me support you again? My mom gave me your phone number this morning. You have to use a fake name, but I'm going to send you a request on my tablet. I'll send you an email. Stacy or something. I've been calling you codename Ollie's mom. Just call me Olive is what Park says. How does your client wish to proceed?
Pleading guilty, huh?
To both? Or was you plead?
To both, as in the violation and the underlying charge, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Put your hand down. Okay, you have the right in this matter as it relates to the domestic violence charge to proceed to trial and the right to jury trial, the right to be presumed innocent until proven guilty, and the right to have the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You understand that, right?
Yeah.
You also have the right in the PA 53 or bond violation to have a contested hearing. And the right to be represented by your attorney at that contested hearing, and the right to have proof put on the record to establish beyond a reasonable doubt if you violated your bond conditions. You understand that? If you plead guilty to the domestic violence, you would give up your right to question or cross-examine any witness called to testify against you, give up your right to remain silent, not have silence be used against you, give up your right to subpoena witnesses to testify on your behalf. You understand that? You wish to give up those rights today? Anyone threatening you to do that?
No, ma'am.
Any promises to get you to plead guilty to the domestic violence and to the bond violation?
I'm going to plead deal.
That's the promise, is to plead guilty?
Plea deal.
What was the plea deal?
It's under certain code.
769 no objection to 769.4A?
Yes.
Okay. Other than that, any promises?
No, ma'am.
Okay. And you understand that by entering a guilty plea, it could result in a conviction that you may need to report to a current or future employer.
Yes, ma'am.
It also could have impact on where you can travel or get immigration status.
Yeah.
Are you on probation at this time?
I am not.
You have another matter pending?
I do.
Is this different victim, you said?
Same victim.
Same victim.
That charge was actually dismissed.
So it's not pending then?
Well, no, I'm awaiting sentencing. The domestic violence charge in the 55th district was,
Oh, okay.
There was an underlining child abuse. So there was a domestic violence and child abuse. I believe the domestic violence charge with the same victim was dismissed as a plea to
The other
child abuse.
charge. Okay, and that's what you're waiting sentence on. As to domestic violence, are you pleading guilty because you believe you're guilty? As to the bond violations, are you pleading guilty because you believe you're guilty?
yes, ma'am.
As to the domestic violence, what is your plea?
Guilty.
As to the bond violation for February 19th, bond violation for February 20th.
So I believe are two different phone calls.
Absolutely, that's why I'm reading them off separately. There was more than one violation. As to February 19th, February 20th, I could read that into the record if you like. And then looks like there was a February 21st, February 22nd. How do you plead?
Guilty.
That's the basis, please.
As to the underlying charge of domestic violence, Mr. Heffley, were you on February 11th of 2026 at the location of 910 American Road, number 107 in Lansing, Michigan, 48911?
I was.
And were you at that location with Josephine Rose Park?
I was.
And did you strike or otherwise batter Miss Josephine Rose Park?
Yes, ma'am.
And was that in self-defense?
No.
The prosecution is satisfied.
Relative to the bond violation that happened on February 19th, Mr. Heffley, did you go against your bond conditions, which specified that you not make any contact with Josephine Rose Park? And did you do that through a phone call? Did you do the same on February 20th?
Prosecution satisfied.
Whereas also set aside as a factual basis, I'll accept your plea if I can see to be freely, voluntarily, and intelligently made as to both the bond violation and to the underlying charge. A matter is scheduled for a sentencing on June 23rd at 9 o'clock in the morning. When you leave here, you're gonna go downstairs and meet with our probation department so they can get you set up for a pre-sentence interview.
Is that all?
It's not on.
Okay.
They'll advise about your domestic abuse status. I'm the one who's gonna make the ultimate decision about whether or not you'll get 769.4A. The fact that you have a now multiple violations does go against my belief that you're gonna comply with court orders. I'm not gonna lie.
I would like to say, since I've been released, I'm attending therapy classes, I'm in a domestic violence class, I'm also in parenting classes, and I'm having a mental evaluation done tonight.
That's good. I'm glad that you're making some efforts, and I'm sure some of those things may have been prompted by some of the other matters that you have pending. The probation office will compile all of that information. They'll also find out about your sentence on the underlying case in, is it 55th? And when are you sentenced on that? What day is that you're sentenced on?
I believe it's the 23rd.
This month? Okay, so they'll find out what your sentence is as well, and they'll advise a status and a report to me, okay?
Okay.
Okay. We'll get you downstairs in just a moment. Any additional matters for the
Nothing
record?
from the people, Your Honor.
Your Honor, would you like the police chief and the vice president?
Yes, please. Thank you.
Nothing further from the fence.
State of Michigan versus Sunday McDonald, 26-00101. Appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Simmons appearing on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Sonda McDonald, who is standing to my right.
Okay, Ms. McDonald was scheduled today for final pretrial. She was still considering a previous offer. How is she going to proceed today?
She would like to plead.
Okay, you have an advice of right?
I thought we had one from last time.
You do have one from 4/7. Raise your right hand, ma'am. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay. You understand the rights that you went over previously with your attorney, which is your right to be presumed innocent until proven guilty, your right to proceed to a jury trial and have the prosecution prove your guilt by proving each element of the charge of animal abandoning cruelty beyond a reasonable doubt. You understand that?
Yes.
You have the right to remain silent at any trial and they can't use that against you. The right to waive silence and testify if you like. The right to see, hear, or question any witness called to testify against you, and the right to subpoena witnesses that will testify on your behalf. You're willing to give up all of those rights? You sure? I think, because I have to hear you.
Yes.
Okay. Anyone threatening you to get you to give up those rights? Any promises being offered to you, not stating here on the record, to get you to give these rights up? Are you on probation or parole? You understand that if you plead guilty to this charge, it could result in a conviction that you may need to report to your current or future employer? You understand that? Okay, it also can have impact on where you can travel or your immigration status. So you might want to leave the country, maybe go on vacation to another country. They could deny you entry for a criminal conviction. You understand that? Okay. There's also an agreement that you won't have any animals, domestic animals in your care or control as a part of this guilty plea. You understand that? Okay. As to animal abandoned cruelty to one animal, how do you plead? Factual basis, please.
Ms. McDonald, on or about August 1st of 2025, did you house two animals at 508 Christian Street in Lansing, Michigan, 48910?
Yes,
And is that in the county of Bingham?
yes,
And were those animals later found to have been suffering from starvation?
well, that's what they say, it's,
I do think that's satisfactory.
You said that's what they said?
no,
Were the animals found to have been severely emaciated?
what I was told, yes,
And so is this the state in which these animals were taken from your home?
yeah, they were skinny,
We're satisfied.
Or is that on the factual basis? I'll accept your plea if I get plea to be freely, voluntarily, and intelligently made. This matter will be set for sentencing June 23rd at 9 a.m. You're gonna go downstairs, meet with probation so they can get you prepared for a pre-sentence interview and advise the court as a recommendation as to how you should be sentenced, okay?
okay.
Do you have any questions at this time?
No,
Any additional matters for the record?
nothing from the people, Your Honor.
Nothing from defense. Thank you.
Patrice Jackson in custody? Patrice Jackson here?
And I see your, our representative Jackson, from my understanding, she had found out, and she's not in the hallway.
Yeah, sure. Trying to figure out why. Because of war status, because they're GPS studies. Because of each other. Oh, okay, got it.
Your Honor, for the record, the complaining witness, Alan Adams is present in the court. If we could ask that his presence be waived for any official court.
Let me note that in the file. But I will note that in the file and he's all set. I think she's already in warrant status for a GPS tether violation.
Yeah, thanks.
Adrian Person is in custody.
Yes.
State of Michigan versus Adrian Person, 5-02220.
Thank you, Your Honor. It please support Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
Assistant Public Defender Justice Straub on behalf of Mr. Adrian Person, who is here remotely.
Okay, Mr. Person is scheduled for a final pretrial on a motor vehicle unlawful use. How we proceed?
Your Honor, we have attempted to make contact with the complaining witness in this case. The people are not prepared to move forward with the trial in the absence of the complaining witness. This time, we asked this case be dismissed.
No objection. Your Honor.
A motion to dismiss is granted without prejudice. Mr. Person, your case is dismissed today. The people do have the right to reissue this against you, okay?
Yes, ma'am.
You're all set.
Thank you, ma'am.
You're welcome. State of Michigan versus Sadie Selden, 26-00650. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
Assistant Public Defender Justice Straub on behalf of Ms. Sadie Sheldon, who is standing to my right.
Ms. Selden was scheduled today for a final pretrial. This is for assault and battery. Did the complaining witness appear? Taylor Selden.
Peter Selden,
I'm assuming they're related.
may I just go along?
Absolutely.
Yes, Your Honor, the complaining witness in this case still appear, the people are not prepared to move forward without the complaining witness. So we ask this case be dismissed.
You should be dismissed without prejudice. We'll get you a copy of dismissal in just a moment, okay, ma'am?
Yes, thank
Do you have any questions for the court? Any additional matters to the record?
Nothing from the people, Your Honor.
Nothing from the bench, thank you.
Who's representing Terry Smith?
Terry Smith, this pro se.
Oh, okay. Sounds good. Okay.
Question I don't-
Okay, and then back on the record in the matter of the state of Michigan versus Martha Thomas. Can you give me Jackson's file back, please? You've had an opportunity to have further discussion with your client. Does she wish to proceed today, or do you need more time to counsel her?
At this point, it is Miss Thomas's assertion that, this was an active situation. So, with that being said, we would like to proceed the trial.
Trial is already set or no? Oh, no, we have to reset it. Yeah, we wouldn't have been able to do it today anyways, because there's 2 trials going on. And we don't have any more jury. July 14th at 8. July 14th at 8 a.m.
Your Honor, in light of the defendant's position, I would ask that the charge at this point be amended to the higher charge, and that we proceed on the malicious destruction of property from 200 to 1,000.
The motion is denied. Any additional matters for the record?
Nothing from the people, Your Honor.
Thank you.
Let's see, State of Michigan versus Almanzar Blanco, 264662481.
Good morning, Your Honor. Sean McDermott on behalf of Mr. Blanco.
Dan Smith, Assistant Prosecuting Attorney for Ingham County, here on behalf of the people.
What's happening? Who is Ramon? That's you?
Yes, ma'am.
Who are you, ma'am?
My daughter.
Translated.
I just speak very well English.
Oh, well, we need to get a translator. We have to get a court translator.
Oh, I'm sorry.
We have one. You speak Spanish?
A little bit. Oh, I speak Spanish. Yeah.
Oh, okay.
I say a little bit English.
Are we supposed to be having a formal hearing, counsel?
It's not my understanding, Judge. Was there any offer from Mr. Smith?
You would know if there was an offer because you would have spoken to him, I would imagine.
I
wouldn't
reached
know.
out, Judge, I did not hear back, unfortunately.
I don't-
Reached out this morning, Your Honor. So
No, that one doesn't count, because you was at court.
I was at. So if he's asking for an offer, I'd request that we make an adjournment and give me time to reach out to him and see if we can.
The civil fraction, use of the cell phone, yeah, texting while driving.
Um,
No, that was what the charge was.
Yes, Judge, that's correct. Are the people ready to proceed?
I think I just told him what the actual charge was. Like, I don't know that we need to recome. If there's an offer, I don't know. What are you looking for, Mr. McDermott, for your client? Maybe
Impeding
start there.
traffic.
Are you willing to amend this to impeding traffic? Okay, is your client willing to, do you know what impeding traffic is?
What?
Impeding traffic is a civil infraction.
Yeah.
Your daughter can explain that.
No.
They'll amend it to impeding traffic, which is another civil infraction. 0 points, it's just a fine. He said thumbs up.
Sounds good, Judge.
When can he pay?
Can you pay today, Mr. Blanco? Almanzar?
Yes, sir.
Today, Judge.
We'll get you to the criminal traffic window. The fine is $135.
Thank you, Judge. Thank you, Mr. Smith.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. Brandon or Price here? No? I don't know. It was a bond show. What am I supposed to do with that? I don't never know. With that. Dependent counsel. Mr. Tortura is out handling business, so he's not ready. Ms. Ballerini is here. This is State of Michigan versus Giannina Ballerini, 25-00894 appearance.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Good morning, Your Honor. Attorney Derek Hess, also public defender, appearing on behalf of Ms. Ballerini. I'm appearing for her felony file. Ms. Ballerini is appearing by video from Kalamazoo Psychiatric Hospital.
And Assistant Public Defender Justice Straub, also on behalf of Ms. Ballerini.
Ms. Ballerini, we did receive a report dated April 30th, 2026. Counsel, did you get a copy of that?
I did.
Yes, we have, Your Honor.
There's been a certification of competency to stand trial, or that she's been restored to competency. Any reasons to make any objections to the report?
Your Honor, this time we do not object to the report. I did have the opportunity to go over the findings with her. She does feel more coherent and understanding more of what's going on than any time in the past. And it's primarily due to medications and injections she's received. She's advised me she will continue to take those injections and medications. And she's expressed an interest to have a package deal worked out on her behalf that Ms. Straub has been talking to Mr. Smith about. Hopefully we can get this resolved.
I'm sorry, Ms. Sharp, did I not call your case? That would happen. I also have a State of Michigan versus Giannini 25-00220, and that it, just those two. Okay, and you're on that file, correct?
That is correct, Your Honor.
Okay. Let's see.
Just briefly regarding the report, they do have the case number suffix as SM. It should be FY. Or maybe add the misdemeanor case number itself to the report.
Did you petition on the misdemeanor case?
That I do not see, Your Honor. There is an extensive number of files, so I've not yet made my way through all of them.
I don't believe she was petitioned on this one. But I have some stuff in here. Petitions on that file, so. I'm sorry.
We will work to cure that.
Not that it's gonna do any difference at this point, but I'm not gonna add, because of that, I won't be adding the file number to that, because there was no formal petition sent on that file. I think we just set it out because she was being,
Thank you, Your Honor. And I would just ask that the suffix be changed from SN to FY throughout the file report.
okay, sounds good. So the court will enter a finding on 25-00893 FY of the defendant competent to stand trial, and the case can continue to the next stage of the criminal process. So was this a matter that needed an exam date? Yeah, well, do you need a PCC?
Your Honor, based on her willingness to resolve the matter, and hopefully the prosecutor will be as well, I would ask for a PCC date on the felony and the pre-trial date on the misdemeanor.
No objection, I believe, Your Honor, we, based off of reading the report, we should be able to wrap these cases up all together. And find a resolution.
May 22nd at 9 AM. The only one of these is a felony, so May 22nd. You want to set them both at 9 AM. We'll do the pretrial the same date. Let's see. Let's go on this. Okay, and your client is still in the facility, is that correct?
Yes, Your Honor. I think there is someone there with her that may be able to give a status on what's going to happen. Your Honor.
Is there someone there with Miss Ballerini?
Yes.
Is there a status as to what's gonna happen next or how long she'll be there?
All I was told was that the doctor was requesting a maintenance order to keep her here until the court was done.
Okay. Okay, I've never entered a maintenance order, so I don't know specifically if there's a scale form for that. So we'll have to get that so that she can stay at the facility until these matters are resolved.
Your Honor, I will look into it this morning and then have my paralegal draft something up for the court.
Very good, thank you. Any additional matters for the record?
Nothing on the beat, Your Honor.
Nothing from the defense, Your Honor. Thank you.
See you on May 22nd. Thank you. Oh, what is the? Is this the word? It says something about the May. So that needs to be checked too underneath. Is that on there? Can I see the competency form on there? Just the form, just the white form that I signed. Should be in that file, yep. Let's see. Yeah, but it doesn't say that. Okay, that probably is the case. I don't know if that will keep her in the facility though. I did check it though. That might resolve it. I removed Tortella because he was doing the most. So let's see if he's ready now. Who's on the iPhone?
Taylor Little.
Thank you. Okay, is it James Tortora?
Yes, ma'am. Yes, Your Honor.
State of Michigan versus James Tortora, 26-00723. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Assistant Public Defender Justice Child on behalf of Mr. James Shapiro, with your views.
Thank you, Mr. Tortora was scheduled for a pretrial today. This is for a reckless driving and FTS property. How are we proceeding?
Your Honor, the people be asking for a final pretrial. No offer at this time.
Where are we having a final pretrial?
Well, we just set it for trial, third trial.
Well, I think the final pretrial would be to see if the complaining witness shows up for the failure to stop, Your Honor.
It's still a reckless driving. I'm setting for a trial. Not having a final pretrial and not needing this community. July 14th at 8 a.m. July 14th, 8 a.m. You must appear in person for that, okay, Mr. Tortora?
Yes, Your Honor.
Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from defense.
We're all set, sir.
Sorry, God bless y'all. Take it easy.
Thank you.
Thank you.
I see the people's response. What did I do with the defendants? Voting. You sorry? Is it underneath that? Oh, it's handwritten. That's why I got it.
Maybe she's.
State of Michigan versus Javon Terry Smith, 25-02764. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Your name, please.
I'm Terry Smith, represent myself.
Okay, and this was a final pretrial. Is the complaining witness here?
But she was the one on Zoom who we,
Oh, over down there. Okay, got it. Okay, and so how the underlying matter, there was no offer, is that correct?
I believe there was an offer for 764, but let me double check.
training tomorrow or something? Yeah, the conference.
Which is what day?
No, Wednesday and Thursday. No. No, Friday. Oh, can you send me my document? I'm sorry. I think I just had sent them. Yeah, but I already sent them. the email. It's fine.
We will be offering a plea, we'll be offering to the miss count one and for the defendant to plead count, the count 2 under 769.4.
Dismiss count 1 and plead to count 2 under 769.4. Okay, so I record a receipt of what is perceived to be a motion for evidentiary hearing and to dismiss you filed. Okay, the court's read your motion. The basis of your motion you state is because the people or discovering your materials that you receive from the people do not establish the required course of conduct under Michigan Compile Law 750.411H because the alleged communication and contact were mutual and not solely one-sided. The parties had ongoing two-way communication, including calls and messages initiated by the complaining witness, which is consistent with a one-sided repeated harassment allegation. That may or may not be true. If it's even if it was true, I don't have the position to dismiss the case on that. That's when you go to a jury. They're the one to decide if it's your word over hers, who's right. So you're saying that there is evidence of some communication, but you say that the communication was both mutual. Well, then the jury will decide if it's mutual or not, okay? The other reason that you're saying is that the responding officer documented no visible injuries on the charge date, and the complaining witness stated she did not seek medical attention or require treatment that day. How is that a basis to dismiss a case?
I don't understand how you can contact the police and say that someone put their hands on you, but there's no evidence of.
Did you read the elements of a domestic violence? Because injury is not a element. They don't have to prove an injury.
Well, also the officers also questioned me at most of those incidents, and I told them that I was attacked as well. And there's only arrest.
Okay, so then that sounds like what you believe is there's a possible defense to. I'm just basing off what you said in limitedly, which is that you were attacked as well. And I'm assuming you're talking about in this particular instance. I don't want you to say too much. If that was the case, then it sounds like what you're asserting is a defense of self-defense, and that's also for the jury. Okay, and then And then you would just have to assert the defense, and then the people would have to prove that you did not act in self-defense. They have to prove that beyond a reasonable doubt as well. You understand that? Okay, last you said the photographs and videos were uploaded several days after the charge date and appear to contain mismatched dates in reference to separate incidents, including events outside the charged incident. That's
Being
not,
charged with something that happened on May 31st, 2025, and there's incidents in the discovery that has nothing to do with the date.
you're talking about incidents of communication, is that what you're talking about?
Communication and pictures, and
Pictures of what? I don't know what you're talking about.
she sent pictures of bruises that have no context and they're out of.
Also, what you're asking is them to charge you with another count for that date. Because that's what they can do. If they have evidence or dates that there was alleged contact that caused bruises on another date that's not charged here, they can just say, Your Honor, I want to make a motion to add another count based on that. You know that? Okay. Not a reason for me to dismiss a case. Let's see, request for hearing. A defendant requests an evidentiary hearing regarding the admissibility timeline and relevance of the later photographs, videos, calls, logs, other evidence. I don't think that an evidentiary hearing is warranted in that case. If they, whenever they try to present evidence at a trial, that's when we deal with whether or not it's admissible or not. You can object if you don't think it's relevant. They can only admit relevant evidence. So they can't admit evidence from an incident that's not relevant to what they're trying to proceed on. You understand that? So your motion to dismiss the case is denied, and there's no basis to have a evidentiary hearing. I know I didn't allow the prosecution to respond. I did read your motion if you wanted to add any additional record. So your matter is already scheduled for trial, I believe. It's June 23rd at 8 a.m. There has been an offer for you to plead guilty to the domestic violence charge. They'll dismiss the stalking. There's no objection to sentencing under 769.4A. That is a special status that if you do a successful term of probation, without any violations, that the conviction of domestic violence will be non-public on your record. You understand that? Okay. And so you'll have time to consider that offer because it was just, I'm assuming it's extended today. So what I'll do is I'll let you decide and you can let us know. And I don't normally do this the day of trial. Okay? Okay, and so you're still going to be representing yourself at the time of trial, correct? Okay, you're gonna wanna read your court rules and your rules of evidence, okay? Understand some questions on how to pick a jury.
I'm unsure.
You're not sure, you might hire an
I
attorney.
might hire an attorney.
Okay, if you hire an attorney, they'll follow their appearance and then we'll take it from there. But if you're going to represent yourself, make sure you read your rules of evidence between now and then, okay? June 23rd, 8 a.m. Any additional matters for the record?
Nothing wrong with people, Your Honor.
Girl said so.
I give my notice to.
We can give you a notice, yes. Did we see Jonathan Wilburn at all? No,
I'll call him.
it was a show cause, but. Somebody to arrest somebody. Do it. You can let them know, we'll take it. Okay. I have Taylor Little here who's representing her. Mr. Amadeo, oh, he's in the room.
Good morning.
Okay, very good. Good morning. And then John Hernandez is here. Mr. Hernandez, can you hear us? Mr. Amadei, are you ready on your matter?
I am, Your Honor.
State of Michigan versus Taylor Little, 25-00247, appearance for the record.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Good morning, Your Honor. William Amadeo, P7619, on behalf of Tara Little. Tara Little, we appear via Zoom. Thank you for allowing such. Taylor, please state your name.
Taylor Little.
Okay, this matter was an assault and battery pre-trial. The matter is scheduled, or it's not scheduled for anything, actually. I just know that she's expecting a child any day now. Is that correct?
When are you due, Taylor?
No, I had him at 37 weeks and 1 day. He just got the NICU.
Okay.
So, Your Honor, I'd respectfully ask for a 30-day adjournment. I'll try to get this resolved. I was appointed after a conflict, and I will reach out to Prosecutor Smith to try to get this done. If not, we could set it for trial if that's acceptable to the court.
I'll reset it for pre-trial. Do June 16th at 10 a.m. June 16th at 10 a.m. work?
Make that work. Thank you, Judge.
Okay, any additional matters for the record?
Nothing from the people, Your Honor.
Not from defense.
You're all
Thank you,
set.
Judge. Thank you.
Thank you.
Thank you.
Sure. Are you ready with Mr. Hernandez?
Oh, yes, Your Honor.
State of Michigan versus John Hernandez, 26-00974. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Justice Smith's job on behalf of Mr. John Hernandez, who is here remotely.
Mr. Hernandez has a domestic violence. And was he on offer at this time?
Yes, I spoke with the defense counsel about the penalty guilty under 769.48.
Your Honor, we would like to proceed to final trial.
June 16th at 8 a.m. June 16th, 8 a.m. in person at the court. Jury trial, July 14th at 8 a.m. July 14th at 8 a.m. in person at the court for jury trial. You have any questions for the court today, Mr. Hernandez?
Oh, no, Your Honor.
Any additional matters, counsel? Anything else?
Yes, I will just put on the record that the plaintiff witness in this case, Alexandria Silva, was present today.
Oh, well, we don't need a final pre-trial then. We just go to trial. No?
Well, I would like to concur with my client, Your Honor, regarding this offer,
He's shaking his head, yeah.
as in he wants the offer or.
Or yes, he wants a trial.
Oh, no, I was just nodding my head like, okay, I don't know. I don't know what's
Oh,
best. so-
okay, so you were not, well, he obviously, there's no offer, it's to plead guilty to the charge, you already talked to him.
Thank you.
So 769.4A, that you could have obviously assumed that they wouldn't object to that, but you're saying you need more time to talk to him about pleading to the charge?
I am, Your Honor.
He could have a whole jury trial, be found guilty of it and still get 769.4A.
Without the people's consent.
They're not objecting.
At this time, we're not objecting. I think if he has a
They
trial,
could,
we would object.
And if they revoke that, Your Honor?
the court still has a determination that they can make.
Okay, thank you.
So I'm just trying to understand why would we require the victim to come back for a final pretrial?
We won't.
Is That change the jury trial date or no? Okay, jury trial, you don't need to come June 16th. Because the victim is already here. July 14th at 8 AM for jury trial, okay? And obviously you still have, your attorney can still let us know the Friday before trial if you want to enter a plea,
Okay,
okay?
okay, July 14th.
There was just one understanding that this defendant, after speaking with the complaining witness, she just has concerns about him giving alcohol treatment. Right, so that's the only concern that we have about whether he enters a guilty plea.
Okay. So if he enters a guilty plea or if he is found guilty, even at trial, the court can order alcohol assessment. I don't see where in my affidavit of probable cause, alcohol was mentioned. I don't know if it's in your police report, but it was not mentioned in the affidavit of probable cause or that he was under the influence at this time. Otherwise, he likely would have already been getting some screening.
I think after speaking with the complaining witness, she says that this is the underlying reason why he allegedly committed the violation due to his drinking. I believe she said that he was. Yes. Yeah.
I couldn't hear.
Do you want to swear her in?
She can tell you for this time period. You can just advise the court.
So yes, she said he was drinking at her house that night when this incident happened. So I'm not sure if that made its way into the police report, but that's is a concern for people.
Okay, I'll note that if he's convicted, whether by a plea or trial, we'll have him screened and get treatment as necessary.
Thank you, Your Honor.
No problem. Any additional matters for today?
Nothing from the people, Your Honor.
Nothing from the fence. Thank you.
Thank you. You're all set, sir. You're all set, Mr. Hernandez.
Okay, thank you, Your Honor.
You're welcome. Is that Mark Anderson?
It is.
Okay, and is Christina Allen here?
She is, Your Honor.
Okay, State of Michigan versus Christina Allen in 24-03442. Appearance, please.
Thank you, Your Honor. May I please report Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Assistant Public Defender Justice Trial on behalf of Ms. Christina Allen, who is standing to my right.
Ms. Allen has a domestic violence case that I think there was another 55th matter that was seeking global resolution and an offer for her to do a mental health court. So she was already screened, I think, for that. How are we proceeding?
This matter is going to be transferred over to the 54th District Court as part of the global resolution. I've signed the paperwork.
55th, you said, for the mental health or?
Yes.
Yeah,
yes. Thank you. This will be transferred. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the fence.
Thank you. You're all set. State of Michigan versus Mark Anderson, 23-01522, 23-02918, 25-01805. 25-02000. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Justice Brown on behalf of Mr. Mark Anderson, who is here remotely.
Did somebody let them know we can do the arraignment? Okay, this is pre-trials for assault and battery. He was being screened for mental health court. How are we proceeding?
Your Honor, I believe this matter, these matters were part of a global resolution. I believe you signed a memorandum of understanding a couple of days ago on one of, I think the 1805 matter. I believe our office has agreed to dismiss these cases as a part of that global resolution.
We already transferred, you're saying, the 1805?
Yes. Let me check. He had a felony case and a misdemeanor case, and I believe we transferred both of those members. And then there's this remaining misdemeanor.
Where's the transfer paper? Because we don't have it.
Haven't signed yet.
Back to my email here. I forward that to Addie.
You say you're gonna forward it now?
Yeah. May I approach you?
Yes. It was on the 30th. On 25-18. Okay. And that was the one Judge Ward signed.
Yes.
Okay,
that's
so I don't know why it wasn't entered.
That's the 1805.
Do we know where the paperwork is? Who did you send it to after you signed?
I sent it to Sarah
Donnelly?
so she could get it re-signed. I don't know if she got it re-signed.
We signed for this.
For the acceptance.
Oh, we'll get it signed over there.
We signed it on April 3rd. For the misdemeanor matter. And then we have the felony matter we need to get signed.
Okay, so the felony, which I don't think I have the file right now, is going over as well.
Yes.
Okay, so I'll note here that a transfer order was signed on that one. These will be transferred. All of these are being transferred, or the other ones are going to be dismissed as part of it?
All of them going to be transferred.
Okay.
I don't think
I will say the case numbers. The case number is not on there. We're not switching it up. What was the plan supposed to be?
that they get dismissed. He just said that.
Don't they all get dismissed if they go?
I don't think so.
No?
I don't think so.
Trying to be funny. I swear, I swear.
I know.
You know,
I don't think they all get
super
dismissed if they go over there. And I don't think that the other court wants all of them.
So we'll dismiss.
Okay, so we'll take knowledge on the other ones. I did already know in 1805 that their order was signed. And then now we need an order signed for the felony, which is scheduled for when? 14th. The 14th. Okay, I'll note that these are gonna be dismissed per global resolution to mental health board. And then we'll get paperwork for the felony before the 14th. After these matters are accepted or signed at the other court, then we'll deal with dismissals on the other one. I'm just noting it.
Thank you.
Mr. Anderson, do you have any questions today?
No, ma'am.
You're all set.
All right, thank you.
Mr. Smith, we're gonna get a paperwork on the felony before the 14th, or correct?
Yes, I can send it over now. So.
Sounds good. Okay, and then who's representing this gentleman?
He was conflicted out to, we find the name.
To whom?
I just need a moment to find the name.
Can you go get the arraignment file from the clerk's office for me, please?
Yes, what's the name on it?
Yeah, his file was sent to conflict attorney Jack Rucker.
Oh, she just said that the files was ready. Just tell me the name. Carola Johnson. Johnson.
Johnson? All right. Who's got it?
Lindsay.
Lindsay? All right.
There's Mr. Rucker right there.
Hello.
Hello.
Morning. Oh, it was on Zoom.
You need to speak to him?
I wait the court would permit him to, yes.
He does not. Does he need an interpreter or no?
I didn't see anything that he didn't speak English. But
Okay. You said it doesn't say that in Nigerians. Okay.
I think it's
Mr. Mbao?
Yes.
Okay, your attorney's gonna log in to meet with you, okay?
Okay, thank you.
You're welcome. What did you need, sir?
the Zoom info.
876 493 1931.
No, I've written it down about a million times. But
No worries.
I'll be there in just a moment.
Thank you. Okay, and then is that all we have to send? I think so. They're in the hallway, I guess. Thank you. Johnson got a lot going on here. Let's see. Is there a file anyway? Oh, this is Johnson.
No, we're done with you today.
That was a different case.
Oh.
Oh, different Johnson. You want a different?
No, it's the same Johnson. You're Corrallo Johnson. It's the same person. He's the one in Lawrence status.
I'm knocking out two birds with one stone today.
Lord. Okay, this is City of Lansing versus the Corallo, is that how you say it?
It's Carvalho.
Carvalho Johnson, this is 24L2903081. Now, this is a speeding that you owe $240 on. When are you gonna pay it?
Within, I guess, 30 days.
What you paying today?
Uh,
What are you paying today?
I don't have anything to pay.
Well, this has
currently,
been
but
going on for 2 years.
This is about the dog thing, right?
Well, I didn't call that case yet. I'm dealing with the speeding first.
Oh,
Because,
sorry.
because we've been trying to get this money from you
How
for
much is
2
that?
years. Well, it's now up to 240 because when you blow us off, the price increases.
No, what happened, to be totally honest, I have been in the hospital the last year and a half. I had 2 open heart surgeries. I wasn't working. So actually, I just started working again 30 days ago. I was.
Yeah, because it looked like the fine
disabled.
was originally $170.
I was disabled. I was not able to do anything for almost a year and a half.
Okay, in 30 days, you're gonna pay how much?
I'm gonna try to pay all of it.
Okay. I'm wondering, what is this? I'm wondering. Okay, I see it where you attached here, even here that you were in the hospital at some point. You emailed, I think, December 16th, but that was 2024. And so
Yeah, I've been going through a lot the last 2 years.
they had given you 30 days to pay $170.
Yes.
If you pay,
I have medical records
if
saying
you
that
pay
I
the
was.
170 by, what is today? June 5th, I'll waive the balance.
Thank you.
Okay, and then I have state of Michigan. That's why I called them separately. One is the city matter, the other two are state. State of Michigan versus Corallo Johnson 24-01552. And then 24-01551. These are both dog license, unlicensed dogs. You did appear for the original court date, but then you didn't appear after that. You have evidence that the dogs have been licensed?
I do not have evidence that the dogs were licensed. What I do have is that, so this is gonna sound kind of weird because all this
Try us, it
stuff,
might not.
all this stuff that we were
Connected?
talking about earlier
Uh,
is connected.
So
I
what
went
about your
through-
dogs?
I went through
Where-
a divorce and my wife.
She
my
kept the
wife-
dogs,
Yes,
so you don't have the dogs?
the dogs were putting down by Eden County.
Show the prosecutor proof that you don't have the dogs, please.
That's why I was kind of trying not to say much when the other case were here, but it's a lot to that case that everyone doesn't know. It was domestic.
And hopefully we never have to hear
Okay, we're fine with that, cases.
it.
Well, I'll
People
move this.
dismiss the dog cases, those are dismissed, so you're all set.
Okay, thank you. So just the 170.
170 by the 5th, I'll waive the balance.
Okay, thank you.
you doing with your?
I just want to confer with the prosecutor briefly and then we can go on the record, Your Honor.
No problem.
No, he doesn't want to do anything with his other two files, and he just wants to go to trial. Yes, that's what Riley told me. For his, we're dropping one of the charges, which was the homeless man that he had, because we have, I put a different on it. And no, he's not pleading anything. We are going forward with both trials for MV and one of them better. Right, but he's not challenging it because he just let him got sentenced to that on Thursday or Friday. That was with no legals. It's because he got hurt with criminal activity. It's sort of about violation.
Oh, he went back to the cabin.
We already got that one. Yeah. That was Raleigh. I went and I was like, do you want to like resolve all of it? And he was like, yeah, he doesn't want you to touch the misdemeanors. Yes. So he is 100% just leaving.
Yeah.
Okay. So I can let
So the,
my witness go.
Yeah, you got a bond violation.
Okay. And we already?
I got.
We already have the hearing for the contract, didn't we?
Yeah.
There's not anything coming. So we are going to release the cattle security. You can. Sorry, I thought you had to be here so
No,
long.
But we'll send you a subpoena for the trial.
Okay, I think they was supposed to be one for, I think, 12. This company, but like automated turrets, that kind of. So I think that's gonna stop.
It's that club.
It's pretty insane.
Every time I go by, I have to like
Oh, right,
make sure
you're
I
right.
don't become a witness because it's always the hours when they let out
Yeah,
situation
yeah.
and we're at the 30th, and so it's just like.
I got you. No, I'm right on Meadoway and Walnut. So I'm between the new homeless shelter and the nearest liquor store.
Oh my goodness.
Like 1 block away from there.
I've
before
heard
that
that's-
quintuple shooting happened.
Yeah, and that's like the centralized. Yeah.
Yeah, ever since the one on Washington burned down.
Oh, jeez.
Yeah, no, my friend who has an office down there is like, I hope they never get the permits to rebuild it.
Yeah.
So it's scheduled the 12th. So we will let you know how many travelers.
Okay.
As soon as we get through the very morning. So
Okay, so just check, it's next Tuesday, so just
Yeah.
check midnight.
Yeah,
Okay.
pretty much. All right, thank you so much for coming.
Yeah, not a problem.
And I'll give you a call.
Okay.
Oh, that got rescheduled. That got reset.
It's again. It's just gonna keep going.
Because,
She,
defense
Carter's, she's not gonna think she's a nurse, so.
Defense counsel is, he had another trial. So he had another self. I think it was like a 2024 case.
Yeah. Oh my gosh, so, you know, thing. We were waiting for it, and I've never seen this since.
Oh, this
Every
is.
time I walked into it, and it was like.
Yeah, yeah, so I guess, yeah, I guess you.
There was a use of it. So that was her. And so he was just sitting there. There's this person, and he very joking to the language because he wanted to specify his transaction. But I guess like the statute. So it was a procedure. And it was like word for word, just the two words that they said. And so then it's like, in the argument was like, you don't have to clarify it's not transactional. And then it was like, I'm not gonna amend it because it's a statute. And then you could argue.
I know.
I think that I would have probably heard.
So like, I understand what they do. And then after it was like, oh my gosh.
Yes, kind of,
Yeah.
that guy.
Well, I have a friend that's a prosecutor in Clinton County, and he was one morning when he told me that we applied about this or something. Okay, well, he tried to, and I walked up to my computer and showed the email, and he went to Clinton County and trash talked me there. As my friend said. It was when I came in and I went, I'll talk to you, because he was like cornering me.
It's like, well, I think this client FTA, this is 2024.
Yeah.
It's like,
Well, that's very nice. I'm talking about this.
Oh.
Yeah. But yeah, that I know that person was trying to see how last time too.
That's the state of Michigan versus Isaiah Hollins. I have 26-00421 and then 26-00999. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people. Assistant Public Defender Joseph Hardy, here. Collins, who's standing here to the right.
Mr. Hollins has assault and battery into 6-00421 and then malicious destruction of property in 999. There's also 2 pending bond violations. One, it looks like he addressed the other one. He was arraigned on the bond violation on May 13th by the magistrate. I can see allegedly picked up a new case. Is that what the bond violation is?
Yes, and he pled guilty to that case this past Friday. The underlying charge of breaking and entering.
Okay, what are we doing on the underlying cases? On the other files?
On the underlying cases, it's my understanding that one of the counts will be dismissed, and that it is our intention to go to trial on the remaining assault.
It's your understanding that what?
It's the prosecution's understanding that there's only one count of assault left. Based on my looking at the online register, it appears that there were still 2 assault counts open.
I'm confused. Let me see here. For plead guilty on count 1, victim on count 2 failed to appear. Okay, that's what's going on. Looks like count 2 victim didn't appear for a final pre-trial. Is that what it was? And there's a jury trial scheduled for May 12th.
Yes.
Okay, and we're continuing to trial.
Yes, and we would like to motion dismiss on the account 2 and proceed to trial on count 1.
That's noted as it relates to count 2. And then what are we doing with the MVOP?
The malicious destruction of property, we'd like to set for a final pre-trial.
June 15th, 8 a.m. June 15th at 8 a.m. Final pre-trial. And jury trial July 14th. July 14th, 8 a.m. for jury trial. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. Thank you.
Oh, one regarding Mr. Collins's bond that was currently set at 1,000%. We would like to motion for modification to the R bond.
Why? So he can pick up another case.
When I was here Friday, I was, I don't want to say told, like, as if it was a promise, but I remember it said it would be amended next time I came.
What will be amended?
Bond.
So I'll address your bond. I don't promise to amend people's bonds.
No, that's, I'm at the lack of intellectual probability.
I don't know what happened in this case last week. What happened last week?
It's my understanding that he pled guilty to the one of the counts breaking and entering.
Nah, I think I vaguely remember. Did you meet with probation to do a PSI?
Not yet.
I think that's what I said. I said that I would not amend your bond until after you met with probation to do a PSI. Just I'm trying to track it down to get that done. They have not done a PSI. Your bond is 1,010%, which is $100. And that was after you had a PR bond, but then got a violation.
This was unlawful entering. When I was out on a PR bond, I attempted to show to my brother's house. I thought he was in the house because I seen people. I wanted to surprise him. And it turns out that the people that I seen were his girlfriend's kids. So they got on the phone with their mom, and their mom told them to call the police. It was not like breaking and entering, but the police grabbed me for that. It was a misunderstanding.
You pled guilty, didn't you?
Yes, ma'am.
So it was like breaking and entering or unlawful entry.
Well, I
You
wanted
pled guilty to that.
I wanted to get it out the way. I didn't want it to seem like I
No,
was
because
neglecting
actually you're pleading
responsibility.
guilty because you believe you're guilty. And you said yes.
Well, because I wanted to have responsibility for
Because you believed you were guilty.
part black, white. You know what I mean?
Because you believed you were guilty.
Because the adults weren't there. For what the adults could say.
What's that got to do with the other case that you picked up, which was what we're studying for final pre-trial?
Malicious destruction.
Yeah, that happened allegedly on April 11th, which
That hasn't
you
been.
would have been on bond. No? No?
Sure that you would have been.
So there's two alleged bond violations for picking up while you're out on bond. So I think, and your bond in that one is 2,010%. Because at that point, you had 3 cases pending. It's like, you're actually getting great bonds under the circumstances. These are phenomenal bonds. They're really low.
I'll show you. There won't be an incident otherwise.
I know there won't. But you don't want to sit in jail on a sentence. I'm not amending your MDOP bond. I think that that's appropriate. You need to pay to get out. And then there's no reason for me to amend the assault and battery if you're just going to be sitting there because you're not getting out on the MDOP bond. You're not eligible for a personal recognizance bond if you're picking up cases while you are out on bond. That means you don't have the ability to keep yourself in line with the court order. And that's why we have had multiple cases during this time. So you need to post a bond. Any additional matters for the record?
Nothing from the people, Your Honor.
Anything else, Mr. Hardy?
No, Your Honor.
Thank you. I just start off this way. State of Michigan versus Amado Mbao, 26-01040. Appearances.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Good morning, Your Honor. Jack Rucker, P86386, appearing on behalf of Amadou Mbao, defendant.
And this is an assault and battery pre-trial. Was there an offer at this time?
There's no offer at this time, Your Honor. I've had discussion with defense counsel. I believe he said that there's some additional discovery that we need to get over to him. I'll make sure we get that discovery to him. At this time, we'll just be requesting of this matter be set for final pre-trial.
June 16th at 8 a.m. Does that work for you? June 16th at 8 a.m., Mr. Rucker?
Works for me, Your Honor.
Jury trial July 14th at 8 a.m. July 14th at 8 a.m. for jury trial work.
Let me check that just a moment, Your Honor. Or July 14th.
Yes.
Open for me.
Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
Thank you, Bond will continue. You're all set for today.
Thank you.
Thank you.
That's right. I'll get find it on the website.
Yeah. What's it? We have our discovery units.
Yeah.
You know?
You want me to send it there?
Yeah.
No, what are we missing?
You can just CC me too.
Okay, perfect. I'll get that out there tomorrow.
Did you check since the first? Because-
Yeah, I downloaded. it.
Okay,
Yeah,
perfect. Cool.
yeah, no.
All right, just wanted to make
Like I
sure.
said, I think it's just like the one body cam, and then I don't know if you guys have the medical records
Well,
for
let me-
Sparrow, or I could just.
Let me click look if we even.
Oh, yeah.
Because I
I'm not sure
don't.
that there's by him.
Yeah.
Because I remember they met at it's the library. Right?
Yeah. There's a whole other incident going on down there at the same time.
As
It
it
was
goes,
like-
many such cases.
That was actually really funny. Because, yeah, she's trying to talk.
Oh,
to the-
is it, where she's like, ma'am?
No,
Yeah, and it breaks
About you're all
down.
set.
Fight happening. with the
That
whole-
body cam made me laugh so hard. I could
Like frozen.
I was like worried for her because she was the only one there.
Mr.
There was, like,
Mbao,
a dozen or so
Yes.
people.
you're free to go.
You're all set, Amadou.
Oh, thank you. So,
So,
how am I gonna leave?
I'll help you.
it should just switch. This is the same.
Yeah.
person.
Yep, yep, yep.
So that's what we have. So we have to.
Right, so there should be.
You want to talk to Middleton? State of Michigan versus Leon Middleton, 26-00997. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith appear on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Leon Middleton, who is here remotely. Mr. Middleton, take your hat off for me. Thank you.
Okay, today was the date that was scheduled for a pretrial. This is for domestic violence and it's like interfering with or lying to a peace officer, serious misdemeanor investigation. I do, however, have a PA 53 bond violation that he needs to be arraigned on. Says Mr. Middleton violated the conditions of his PA 53. It said he attempted to contact Amber Watts through the Ingham County Jail phone system, and also had multiple friends reach out to Watts in an attempt to get her to call him. So you have the right to have a contested hearing, because that would be a contempt of court violation if you're guilty of the allegations that you used a recorded phone line at the jail to try to make contact with the person that you were told you couldn't make contact with. And if you're found to be in violation, you could be sitting in jail for 93 days for the violations. And you could also be sentenced to contempt of court of up to $7,500 in fines. Do you understand that, sir?
Yes, ma'am.
Looks like it says Officer Bridget Boyson has already sent some screenshots of text messages of alleged contact in violation of the court order. Okay, and so was there an offer on the domestic violence?
No offer on the underlying charge at this time, Your Honor.
He's currently untethered. Are you untethered, sir?
Yes, ma'am.
How does your client want to proceed?
It is my understanding, Your Honor, that he will be pleading guilty to the violation.
He's gonna plead guilty to the violation?
That is correct.
And what are we doing with the underlying matter?
We would like to proceed to final pretrial, Your Honor.
Is he employed?
He is. He's
Where?
currently at work, actually.
Where?
Where are you employed, Mr. Middleton?
It's called Maryland. Well, I got the badge right here. It's
Meridian?
Meridian, yes, ma'am.
No offer. Final pretrial? June 16th at 8 a.m. June 16th, 8 a.m. You must appear in person at the court.
Okay.
Your trial July 14th. July 14th, in person at the court, 8 a.m. for your jury trial. As to the violations, do you want to plead guilty?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
You can put your hand down. You have the right in this matter to have a contested hearing and the right to have the prosecution bring forth evidence to establish your guilt as to those violations that have been alleged against you for making jail calls. You understand that?
Yes, ma'am.
You want to waive your right to have a hearing and plead guilty?
Yes.
Anyone threatening you to do that?
No, ma'am.
Any promises to get you to plead guilty?
Can you repeat it again?
Anyone promising you anything to get you to plead guilty?
No, ma'am.
As to the allegations that on or about April 15th, that you made attempts to contact Amber Watts through the Ingham County Jail phone system, and that you also had multiple friends reach out to the alleged victim to make contact. How do you plead?
Plead guilty.
Factual basis, please.
Mr. Middleton. Did you on April 15th or 14th, was it 14th you're on?
I think 15th.
Okay, did you on April 15th reach out to the complaining witness in your underlying domestic violence case named Amber Watts?
Yes, ma'am.
Okay, and was that in violation of your bond condition
Yes,
provided
ma'am.
by this court? And on that day, did you yourself reach out to her as well as had other people reach out to her?
It was like other people.
Okay.
People are satisfied.
The court is satisfied with the factual basis. I'll accept your plea to the violation. I find your plea to be voluntarily and intelligently made. You can address the court for sentencing.
Your Honor, relative to the underlying, or excuse me, the bond violation, Mr. Middleton did readily, he was forthcoming relative to his behavior, and he does acknowledge that this court was gracious enough to give him a bond, and he recognizes that violating the bond order was not the right thing to do. He takes full accountability for that. Based on his willingness to accept responsibility, we do ask this court to consider perhaps time served.
Time served.
I do think he has.
When did he serve time on the violation?
He did not, Your Honor.
So how can I give him time served for something he hasn't served on a violation?
I thought I had seen this court do that before. Maybe I'm wrong.
Time served on the violation?
Yeah.
Yeah, if they had served time on it, but he has not. So that's typically, we arraign you while you're still in there on the violation and you're sitting there, or because you've been remanding pending a hearing or something. And so at that point, I would likely consider a time served, but that's not his case. Yeah, it looks like he was given a bond. I don't know when he posted it, but we didn't get notified of the violation until February 22nd. He was not in our custody when this bond violation was issued. And then there's just a blatant disregard for court order. I'm looking at the affidavit of probable cause, and it was concerned even then that the amount of times that he called the alleged victim from the jail, but this was prior to his arraignment on the alleged date of the incident. But then after being arraigned and then after being told that you're not to have contact directly or indirectly with Amber Watts, and then after being told that you're not to have any third parties communicate with her, for you to make attempts and to yourself make contact with the protected party in violation of a court order on a recorded line, it's just like, it's ridiculous. Like, you have no regard for a court order. And so I don't know if, I don't know how we're going to move forward with Mr. Middleton if he can't follow court order. I don't know if he's gonna be able to keep his job at Meridian, because we have to put him in jail to get him to comply. Where are you staying, sir?
274 Ethan Rapids Road.
Okay. I'm gonna sentence him to 30 days Ingham County Jail, which I will suspend upon the resolution of this file if there are no further violations of the court order. So you're not to have contact directly or indirectly with Amber Watts. That means you can't call her, you can't text her, you can't slide in her DMs, you can't write her a letter, you can't send any smoke signals, you can't use a pigeon to deliver a message. No forms of communication. Do you understand that?
Yes, ma'am.
You neither can have anyone else try to do it for you. Do you understand that?
Yes, ma'am.
You're not to be within 2,000 feet of wherever she is. Do you understand that?
Yes, ma'am.
Okay. Do you have any questions or concerns about your bond conditions or any things that you don't understand?
No, ma'am.
We're completely clear, correct?
Yes, ma'am.
Okay. The bond otherwise will continue. We'll see him in person at the court on June 16th. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from, thank you.
You're all set. Thank you. Mr. Middleton, you're all set.
Okay, thank you.
You're welcome.